my name's Tom Carnahan. I've been doing arbitrations for over 25 years, and I've been asked to put together this video to help you understand, if you do come to an arbitration, what's going to happen. But first, let me hope that you have taken the time to review the video of mediation, because much to your surprise, over 50% of the time, if you go to mediation, you will settle that case and never have to come to arbitration. But if you don't, and you come to arbitration, the first thing that happens is everybody comes in, puts their paperwork down, the complainant's on one side, the respondent's on the other, and everybody that's going to testify is sworn in. After that, the complainant does their opening statement, which includes the dollar amount that they're requesting in this arbitration. Then the respondent's opening statement, which is any way they want to present it, of just the opening statement, not all of the facts, but just the opening statement. Then the complainant has their presentation of their evidence. They state their case and present any witnesses that they have brought with them to be questioned. So that's the first part of it. Then we get into the cross-examination by the respondent of the complainant. And that's where the respondent asks questions of the complainant with the material that the complainant has presented. Then questions from the panel members of the complainant, if there are any. The next thing that happens is the respondent presents all of their evidence, they state their case, and bring any witnesses in that they might have brought with them to be asked the questions, to state the facts that help their case. Then, after that, cross-examination by the complainant. That's where the complainant asks the respondent any questions from the material that they presented. Finally, you get into the rebuttal evidence. This rebuttal evidence means new, not existing, new evidence or testimony which contradicts what was presented by the other party. It does not mean repeating the same material already presented. Prior to the closing statements, the parties are reminded that they may take a recess to try and settle the case between the two of them without having to give it to the panel for final decision. A lot of times, you'll be surprised when you get there and you talk to each other, maybe you can find a way to settle the case without the arbitrators having to do it for you. If a settlement is reached, which hopefully it will be, you will be provided an arbitration statement agreement to be completed by the parties and their counsel, and the arbitration process will be terminated. If you don't settle, and a lot of them don't, then at that point, the complainant will give their closing statement, wrapping everything up into why they believe that they're the ones that should get the arbitration. After that, the respondents have the same opportunity to give their case. Then, when all the evidence has been presented and everything is done, the panel member, who is the chairman of it, will ask all parties, do you feel you've had a fair opportunity to present your case? We'll look for a yes answer from every single party before we adjourn. After that, we will excuse all of you and tell you that you will get the final in a week to 10 days of what's going to happen as far as that arbitration is concerned. Hopefully this has been helpful and you understand what the process is. You will be nervous when you come in, so take a couple of deep breaths, smile a bit, and try your best just to be calm and present your case as best as possible. Thank you very much for taking the time to watch this video, and good luck.